This is number 4 in our series of 5 videos with King County District Court, and our returning expert is the Honorable Kristen Shotwell. Welcome back, Judge Shotwell.
Well, thank you again for having me and for developing this video series. I hope it helps the people out there.
I'm sure it will. So the topic for this session is what to expect at trial. And to lead off with that, when does a case go to trial in small claims court?
Good question. A case will go to trial in King County Small Claims after the plaintiff proves that the defendant was properly served. And we have a whole other video section on that, I believe. So after proof of service and after the parties have made a genuine attempt to resolve their dispute through mediation offered by the Dispute Resolution Center.
Okay, and that's covered in video number 3. So if we made it to the trial stage, what actually happens at trial in small claims court?
Yeah, so both parties must appear in person at the courthouse. They'll bring with them all the evidence they want the judge to consider. They should bring 2 copies, actually, one to hand up to the judge and one to keep for themselves so they can reference that during the hearing. The trial or the hearing will last about 40 minutes, 20 minutes approximately for each side. Witnesses are typically not allowed in small claims cases. That's up to the judge. These are less formal trials than a regular civil case, and the rules of evidence do not necessarily apply. So the focus is on speed and efficiency and fairness, not necessarily formality. At the trial, the plaintiff should really focus on 3 things: how much money they believe they're owed, why they believe they're owed the money, and how they arrived at that amount. So show the judge the math.
You got to show your math.
Exactly, show your work. The defendant, on the other hand, should focus on defending those points. So why they don't think they owe the money or why they don't think they owe that much.
Okay. And just to clarify that the plaintiff is the person who actually starts the lawsuit with small claims court.
That's right.
And the defendant is the person who is answering or responding to the suit, correct?
That's absolutely right.
Okay. Who has the burden to convince the judge?
Well, the plaintiff, the one who started the lawsuit, has the burden to convince the judge by a preponderance of the evidence, and we'll talk about that in a minute, but they have to convince the judge of the truth of their claim and prove the amount of their damages, meaning show their math, explain why they think they're owed a certain amount.
And you mentioned the phrase preponderance of evidence. What exactly is that?
Well, that's a standard of proof in the law used in civil cases. Most people are familiar with beyond a reasonable doubt because those are frequent TV shows, criminal cases. So beyond a reasonable doubt is the criminal standard. It's very high. Civil cases like small claims have a preponderance of the evidence standard, which really just means more likely than not. So 51% to 49%. It's a lower standard than the one people are familiar with.
Okay. So the trial ends. What happens if the plaintiff wins?
If the plaintiff wins at trial, the court will issue a money judgment. A judgment is a court order saying that somebody owes someone else, a certain amount of money. The judgment will include the court costs like service of process fees and the filing fees. And the judgment does have interest accruing on it. So interest accrues daily, and that means the judgment amount the person has to pay is going to increase daily until it's paid.
Okay. What happens if the other side, the defendant, wins?
Well, if the defendant wins, the court will dismiss the case and may order the plaintiff to pay any costs associated with the suit that the defendant incurred. So plaintiff wins a money judgment. The judge does not order the defendant to take out their checkbook and pay right then and there. They get a piece of paper called a money judgment that the plaintiff then has to go and collect upon, which sometimes involves hiring an attorney and may involve proceedings like liens and garnishments in court.
Okay. And what if someone, whether it's the plaintiff or the defendant, does not agree with the outcome of the trial? What do they do?
Sure. Every party has the right to appeal the verdict or the outcome of the trial. The appeal has to be filed within 30 days. That's a very hard deadline, and if people do not appeal within 30 days, they may lose their right to appeal.
Okay.
The appeals are heard in the Superior Court. That's the court that sits one level above the district court, and involves the judge from the Superior Court listening to the recording of the small claims trial and making their own decision about the evidence. The parties do not present evidence at the appeal or even necessarily appear.
Okay, I want to reiterate that one more time. That's such an important point. Parties do not get a chance to present any new evidence.
They
Correct.
don't. The evidence that the judge on appeal will consider is only the evidence that was presented during the trial in district court. So the recording of the proceeding and any evidence or exhibits that were handed up to the judge.
Excellent. Thank you very much for your contribution again, Judge Shotwell. Take care.
That's great. Thank you.